I believe we're live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
I want to thank council for appearing via Zoom for this February 2nd, 2022 setting of the 7th Court of Appeals via Zoom. We understand that the weather circumstances have caused a last minute reconsideration of how this will be presented. But again, thank you for, how do you say, going with the flow and so we can proceed with this case. I'll go on and call the docket. And before I do, I'm not sure either one of you have argued in front of us before. So just some quick admonitions or information. Both sides do have 20 minutes to argue their respective case, and the appellants automatically have a 5-minute rebuttal, so you don't have to ask for a reservation of time. You get that anyway. Always welcome to use the entire period, but don't feel compelled to use the entire period. We do ask, or we tend to ask questions. So please answer them as directly as you can and as succinctly as you can, and things should proceed smoothly. With that, we'll go on and call 7-21-00163-CV International Bank of Commerce, Oklahoma versus Lane Gorman, Trubitt, L.L.C. Colin excuse me if I mispronounced this, Kanalekos and Patrick Riley. Are the appellants ready to proceed?
Yes, we are, Your Honor.
Thank you. Are the appellees ready to proceed?
We are, Your Honor.
Very good. And if you'll note, we have in one of the boxes up on our screen, we have a timer, and that will be the official time. And Mr. Thetford, whenever you're ready.
Your Honor, thank you again for allowing us to attend by Zoom. That sure helps us from the location we're in, and we're grateful to Rhonda for getting everything set up and coordinating this.
Sure.
With that said, Your Honor, let me begin my argument. First of all, this is arguably the biggest auto dealership fraud in Texas history. Brieger Dykes Auto Group defaulted on up to $200 million in debt. There were 16 RDA Brieger Dykes Auto Group employees and owners that have been found guilty of criminal fraud in federal court. This whole scheme began back in 2015 and 2016 with LGT, the auditors in this case, assisting RDAG in putting together their accounting books. Unfortunately, my client, IBC, was one of the creditors who got burned in this scheme due to the reliance on LGT's audits. IBC brought this lawsuit on June 27, 2019, premised primarily on a negligent misrepresentation claim and a fraudulent misrepresentation claim against LGT, which was, of course, Brieger Dykes Auto Group's auditors. In June 21st, 2021, the Honorable Judge Mackie Hancock granted LGT's motion for summary judgment on all claims. Your Honor, our primary theme in this case is that the judge improperly weighed the evidence rather than construing the evidence in the light most favorable to the non-moving party. The elements of a claim for negligent misrepresentation requires proof that a representation was made in the course of defendant's business for guidance of others. In this case, the next element is defendant provided false information. Number 3, defendant did not exercise reasonable care in obtaining or communicating the information, and that plaintiff suffered pecuniary loss. In an attempt to simplify our arguments, Your Honor, I want to focus the court on a case that is almost identical to the facts of this case. We will, at the end of the day, we won't be offering much argument on the law. I feel this case is more centered on the facts And that's what we're primarily going to focus in on, with the exception of the case I'm getting ready to discuss. And that case is Irvin versus Mann, Frankfurt, Stein, and Lip CPAs.
Counsel, is that in your brief?
Yes,
Okay.
we've cited that case in our brief.
Okay.
Your Honor, this case, and let me give you the site. The site to that case is 234 Southwest 3rd, 172. That's 234 Southwest 3rd, 172. It was decided in 2007. It was heard by the Court of Appeals of Texas in the San Antonio Division. The court in that case focused on the restatement of torts, section 552. The facts of that case are as follows. Investors in a company brought an action against the accounting firm based on undisclosed liabilities. The Irvin group sued the auditing firm MFSL, which I'll abbreviate, is for short for Mann, Frankfurt, Stein, and Lip, saying they failed to perform a balance sheet audit on a South Texas music / South Texas record and tape company for the proposed purchaser, Robert Gorman. South Texas records and tapes ultimately sold to Gorman, who hired MFSL. Gorman was the majority shareholder of the buying group, and the Irvins, the plaintiffs in this case, were recruited kind of after the fact to become minority shareholders in that transaction. Before the Irvins bought into South Texas Records, they were provided the audit prepared by the CPAs, MFSL. The audit was supplied to the Irvins unbeknown to MFSL, the auditors. The audit was a balance sheet audit only, and just like in this case, MFSL claimed that the engagement letter was prepared only for use by South Texas Records, and any other use was prohibited. They claimed that it was South Texas Records work product only. The auditors claimed in that case that the Irvin Group did not fall within a class of people that MFSL intended to receive the audit. The trial court granted the motion for summary judgment to the auditors, and the appellate court reversed on all counts. From a procedural standpoint, it's much like our case. The auditors filed a traditional motion for summary judgment and a non-traditional motion for summary judgment. The elements the court cited were the same as I said in my opening. There must be a representation made in the course of the defendant's business for guidance of others. Defendant provided false information. Number 3, defendant did not exercise reasonable care in obtaining and communicating the information, and the plaintiff suffered pecuniary loss. Specifically, the Court of Appeals held potential plaintiff does not have to be specifically identified or even known by the defendant when the information is supplied. In other words, MFSL, even though they didn't know of them, and the fact that the Irvins were never identified was not a defense to a negligent misrepresentation claim. The court went on to say, it is sufficient if the maker supplies the information for repetition to a certain group or class of persons that the plaintiff proves to be one of them, even though the maker never heard of him by name when the information was given. And that's a key point. It's when the information is given, not when the audit is completed. And this is on page 177 of the Irvin case. So it's the date the information is supplied, not when the information is created, that counts. And actual knowledge of the auditor is not required.
Counsel, is that when the auditor supplies the information, or when the party who has defaulted supplies the information? Whose supply are we focusing on?
Your Honor, as I understand it, it was supplied by the Julian Group, in this case, which was the majority shareholder. So it was when it was supplied by Julian to the minority shareholders. And that's my interpretation of the Irvin decision on that point.
Okay.
And it all goes back to foreseeability. It goes back to were the Irvins, who were also shareholders in this transaction. It goes back to whether the auditor knew or should have known or could foreseeably seen and anticipated that audit going to other class members within that shareholder class. And the court ruled that that was sufficient from a knowledge standpoint, and that element of the negligent misrepresentation had been met.
Just to clarify something in my mind, the audits we're talking about this year in this case, were 2015, 2016, 2 audits?
That's correct, Your Honor.
Okay, and the IBC loan was when? 2018?
Your Honor, that's a very great question, in that there were 2 tranches of loans. The first one was kind of a blue sky loan for $10 million that specifically only relied on a 2015 audit. And then the second one was a real estate loan for an excess of $25 million that occurred and was distributed that was distributed in February of 2018, after the 2016 audit had been released. And the 2016 audit had not been released until November of 2017. So they were struggling with all these issues, the auditing firm was, and they couldn't release the 2016 audit till November of 2016 and of 2017, Your Honor. They didn't release the 2016 audit until November of 2017. And the final tranche of money from the real estate loan was not released until February of 2018. And it was specifically conditioned on the receipt of both audits.
Okay, it was the nature of the loan agreement between IBC and Rager Dykes such that if circumstances arose in the interim between the time the loan was approved and the funds were actually dispersed, that they could have canceled, they could have rescinded the loan?
100% yes, Your Honor. And there's emails and communications in the record that specifically detail we're not going to release the balance of the proceeds from the original approval of the loans for the real estate loan until IBC receives in hand the 2016 audit. And yes, that was expressly conditioned on receiving that audit and reconciling it with the 2015 audit. So it's kind of a cumulative analysis. Without both, IBC was unwilling to release the balance of the proceeds. Now, Mr. Kaufman, on behalf of LGT, argues that the blue sky loan does not fall within this analysis. And we might ultimately concede that the first $10,000 was not part of the condition of the 2016 release. So the first $10,000,
10 million.
the first 10 million, godly, I'm losing my mind. The first $10 million was released, and LGT may in fact have us on that issue with the first 10 million. But on the second tranche, the big tranche that was collateralized by the real estate, that was the part that we relied on these representations made by LGT. And we in fact have, and for the 2016 distribution the distribution that occurred in February of 2018, premised on the 2016 audit release, those proceeds were specifically tied to the 2016 audit. And if I may, there's no question, as in the Irvin case, that IBC was part of a limited class. In Irvin, the court construed, even though the auditors didn't anticipate, didn't know of, and was not aware of the Irvins, they still fell within a certain class of parties that would foreseeably rely on that audit. In this case, IBC Bank fell within the class of creditors that existed back in 2015 and of course in 2016 that would have been anticipated to rely on those audits in order to make their final distribution decision.
What does the record show with regard to why Rigger Dykes contracted with the accountants to undertake an audit?
Yes, Your Honor, and that's covered in the Irvin case also. In the engagement letter, they say specifically they're trying to raise proceeds to take the company public. And in the Irvin case, there was limiting language in their engagement letter also. And it said it was for the limited purpose of something, far more narrow than what the Irvins were using it for. And the court similarly disregarded the engagement letter because it all goes back to foreseeability the court held.
So it does not necessarily need to be related to use for obtaining loans.
If I understand your question correctly, yes, Your Honor. They claimed it was simply for bringing the company public, but they were aware, LGT was aware of IBC prior to the release of the 2016 audit, and they were aware of them through emails and other communications wherein LGT was specifically CC'd by RDAG employees and owners that they were refinancing this debt and that LGT would be a partner moving forward in refinancing the real estate. So,
Mr. Thetford, you mentioned in your elements of your cause of action, one of those elements being the sustaining of economic or pecuniary damages. The appellees maintained in their brief that when you consider the credits and offsets that should be allowed, that IBC suffered no pecuniary damages. Would you address that argument?
yes, Your Honor. And I don't have the specific citations in front of me, but the general gist of all of the cases that we reviewed and cited says that it's the satisfaction of the judgment, not the obtaining of the judgment that counts. So it's only the satisfaction. The record is clear. We have never received full compensation for the loan proceeds we lost due to RDAG's default. So the only issue is how much of those judgments have been satisfied. And we have demonstrated that it's a number greater than 13 to 16 million dollars that have not been satisfied.
Was that part of the, is that part of the dispute between the parties here with regard to the settlement credits versus satisfaction? Because if I recall correctly, Mr. Thetford, in your brief, you talked much about the one satisfaction rule, whereas Mr. Kaufman in his brief talked about settlement credits. And is one satisfaction rule the same thing as settlement credits, or are they two different things? And I guess in talking about settlement credits, he was looking at the statute, Texas statute, that purports to require consideration of settlement credits.
Your Honor, I think as far as the facts are concerned, we're all in agreement how much has been satisfied and how much has resulted as a result of judgments. I don't think that's a dispute. But we strongly disagree with Mr. Kaufman and LGT's characterization that it's the obtaining of the judgment versus the satisfaction of the judgment that counts for all set-offs. And
so in your view, then, one satisfaction rule would be similar then to, or just another way of saying the settlement credits? They're all the same thing. You got to get the money before you can offset it?
Yes, Your Honor. I clearly think that it's the satisfaction of the judgment, not the judgment itself, if I'm answering your question properly. And so the other thing I want to read the court, and Mr. Kaufman and LGT spend a lot of time on this, but again, this is in the Irvin case. And this seems to be the crux of the majority of their arguments. And I want to quote from the Irvin case, and it says, direct communications by the professional to the user is not required to establish standing, nor is it necessary that the professional have any particular person in mind as the intended or even probable recipient. In other words, a potential plaintiff does not have to be specifically identified or even known to the defendant when the information is supplied. Rather, it is sufficient that the maker supplies the information for repetition to a certain group or class of persons, and that the plaintiff proves to be one of them, even though the maker never had heard of him by name when the information was given. And to me, I felt like, I know I'm kind of digressing in our thoughts here, but I just think that's a real important point. And that's on page 177 and 178 of the Irvin case. And I think that's a real important thing for the court to note for the purposes of their review of this appeal. In conclusion, Your Honors, we would conclude that we feel that the court went so far as to weigh evidence. There's clearly evidence of falsity of the audit. Lowell Joel, a very experienced accounting expert who wrote many of the Thomson Reuters guidelines that LGT uses and references, upwards of 61 of his guidelines have been published through the GAAP proceedings. He concluded there was at least 5 false representations in each of the 2015 and 2016 audits. So that part of the claim is satisfied. And then when it comes to knowledge and purpose, I think I've covered that with the Irvin case, based on you don't have to have actual knowledge. The auditor does not have to have actual knowledge. All they have to know is it anticipated these parties would rely on this information, and that, you know, if the information is false, would they suffer pecuniary loss? So that's kind of the sum total of our arguments for the time being.
Thank you, counsel. Any questions? Thank you, counsel.
Thank you.
Whenever you're ready, Mr. Coffin.
I'm ready, Your Honor, and may it please the court. Your Honor, IBC's theme is that Justice Hancock, who was sitting by assignment, improperly weighed the evidence. We couldn't disagree more on that point, because there is no legally sufficient evidence, no scintilla of evidence that's going to support IBC's claims. The truth in this case is that IBC made a bad business decision. In 2017, summer 2017, it agreed to loan what would eventually become $35 million to Rager Dykes, a blue sky loan and a collateral real estate loan. And they did this by looking at 3 things. First, they looked at Rager Dykes' cash flow, which my client, Lane Gorman, did not audit at the time. They looked at the guarantor's assets, the assets of Mr. Rager and Mr. Dykes personally, which my clients did not audit. And then they looked at the collateral real estate value, which was a number inside the 2015 audit, but it's undisputed that IBC didn't rely upon that number. They went and got their own independent appraisals, that dramatically increased the value of these properties so they could meet their loan lending requirements and approve these loans. In other words, IBC didn't look at or rely upon any of the information in the 15 or the 16 audits that my clients prepared to approve or fund loans to Rager Dykes.
Let me stop you there. Just
Yes,
I want to clarify a fact. You're saying that IBC had additional appraisals done that raised the values?
That's correct, Your Honor. After they approved the loans in the summer of 2017, they hired their own independent appraisals, CBRE, to come in and do their own appraisals of Rager Dykes' real estate. And those appraisals, in fact, increased the value of the properties by more than $15 million over the cost basis that was indicated in my client's audit reports for 15.
Okay.
As it's been well documented in this case that in 2017 and 2018, Rager Dykes engaged in fraud that eventually caused his bankruptcy in August of 2018. Of course, this resulted in a default of its loans with IBC. And IBC was looking for someone to blame for its aggressive lending practices. It settled on Lane Gorman Trubitt, my clients. But the problem is that my clients didn't audit the years when the fraud was happening. That was 2017 and 2018. Our last audit was for fiscal year 2016. And there is no evidence in the record that there was any fraud going on at Rager Dykes in 16 or in 15, the other year my clients audited. To try to save it.
Counsel, if I may, that's in reference to the check kiting, basically?
There's check kiting and there's a floor plan fraud as well. Yes.
Okay. There were some allegations, and again, correct me if I'm wrong. It's been a while since I've read the briefs, but there was some allegation that there were misrepresentations in the audit with regard to what current assets were, which does not necessarily relate to the fraud, the floor plan, or the check kiting. So that's one instance. In that time, the timing there, would that have been something that would have been in the audit that IBC saw in assessing whether to extend loans?
Yes, Your Honor. And if I may share the screen, I can show you a visual of that misrepresentation that they're referring to.
As long as we don't lose feed.
As long as we what?
Don't lose feed.
Sure. Actually, this disabled the screen sharing.
Is it?
Rhonda?
Yes, Ms. Silverman, can you enable it? She talked about that and told us that you were going to do that, and we said it's okay.
Yes, one moment.
While she's getting that ready, I'll explain this issue with these misrepresentations on the balance sheet. What IBC's expert has opining on is that there is a misrepresentation on the balance sheet with regard to due on demand debt and shareholders receivable. He's not saying that my clients got the numbers wrong. He doesn't rewrite those numbers. He just puts them in a different spot. And I can share my screen now and show you this. What he's saying is that he wants to classify accounts receivable, related parties, and employees. This is the money that Mr. Rager and Mr. Dykes personally owe Rager Dykes. He wants to reclassify that number, and then he wants to reclassify the due on demand debt, which is notes payable current portion, because it was actually due. It could be due sooner rather than later. And what happens on this is that they're saying, well, the current ratio, which is the current assets to current liabilities, that would have been less than 1-to-1. And you can see his recalculation right there. And IBC says in their reply brief, well, no bank's going to approve a loan if the current ratio is less than 1-to-1. Well, the problem with that, Your Honor, is that they never looked at the balance sheet to approve these loans in 15 when they're looking at it. If you go look at their testimony, what they looked at was three things. They looked at the cash flow, and the cash flow is not on this page. This is the balance sheet that he's doing the reassessment on. The cash flow is actually a different sheet of the audit report. You can see the audit reports here, clerk's record starting at 77. And if you go, this would be the balance sheet where he's doing his restatements. The income and equity statements are here. Cash flow statements are here. Clerk's record 83. You can very clearly see at the top that it's unaudited. And if you go back and look at the front of the cover sheet of this, it says the cash flow statements are going to be unaudited. And that's key. The reason why it's unaudited is this is the first year Rager Dykes had an audit. In the first year you do an audit, you just look at the balance sheet, you get the balance sheet audited. And then in the next year, you can come back and you can do a full financial statement audit. So this was unaudited. But the problem IBC has with this case is that when it approved these loans in summer 2017, it apparently didn't realize that this was not audited. Its loan officer did a poor job of communicating that to the loan committee. And how do we know that? Well, we know that because we have an email from IBC's chief credit officer, David Moore. And this email is very telling. He says in an after the fact look back, he didn't realize that this was a balance sheet only audit. The audit letter specifically states the income statements, cash flow, and equity statements were not audited. The income statements were the primary source for verifying profitability and cash flows. I don't think the loans would have been approved if the loan committee, executive committee, and Oklahoma board knew that the 12/31/15 audit was only for the combined balance sheet. Proving that is another story. The lender, being IBC, was clearly negligent in his presentation of the scope of the audit. That's what Mr. Moore, IBC's own employee, concluded, that this went over their head. They didn't realize it wasn't audited. And that's how their reliance breaks down in this case. The other two factors that
was Mr. Moore part of the group or whoever that made the decision to make the loan?
The record reflects that he was part of those meetings. I don't know how much say he had in those meetings, but if you go back and you look at the meeting minutes in the record, you'll see that his name is on there. And we do have the testimony of several other individuals that were part of that group. And that this is what IBC says shows reliance. But again, we're having problems. They're having problems establishing reliance. Because if you look at the testimony of Mr. Schonecker, who is the president of IBC Oklahoma, you can see his reliance testimony right here. And he says, well, we wouldn't have approved these loans if we would have known that there was if we would have known if we didn't have the audit. But the problem is he never ties this back to those misstatements on the balance sheet that we just looked at earlier. There's no mention of that. They also cite to the testimony of Mr. Woodring. And Mr. Woodring was the loan officer. And he talked with CJ Sidorsky, who is a credit officer there. And they can't remember the conversation. They just remember spreading the numbers. But they don't tell you what numbers are spread. They don't say if it's from the balance sheet where IBC's expert has identified these alleged misrepresentations. And then they talk about the testimony of Mr. Levinson. He is the Tulsa branch president. Well, Mr. Levinson, though, only talks about the 16 audit report. He doesn't talk about the 15 audit report and reliance. And we can talk about the 16 audit report in just a moment on the reliance aspects. The other key piece of evidence that IBC relies upon is this loan memorandum. And this is a critical document in this case because this reflects IBC's mental processes, what they were thinking at the time that they approved these loans. And it's hard to read on the screen. I'll zoom in a little bit, but you can see that these are the three factors they're looking at. They're looking at cash flows, which we've seen weren't audited. They're looking at guarantors' assets, which my clients didn't audit. And they're looking at the liquidation of collateral, which, as I said, they went and had their own independent appraisals. None of this ties back to the misrepresentations that are identified by IBC's expert on the balance sheet. Furthermore, IBC has a reasonable reliance problem, both with regard to the 15 and the 16 audits. There were just too many red flags for a $13 billion banking operation as sophisticated as IBC to approve these loans in the fashion that they did. Remember, we just looked at the cash flow statement. The cash flow statement is unaudited. And that was, according to Mr. Moore, the primary source for verifying profitability. Well, if you look at the Willis versus Marshall case out of El Paso, 401 Southwest 3rd, 689, that case says that if you're relying on unaudited numbers that have a disclaimer at the front of the document, which this audit certainly has a disclaimer that says we're not expressing an opinion on cash flows. Well, you cannot reasonably rely upon those numbers as a matter of law. That's what the Willis versus Marshall case says. The guarantor assets, well, we saw earlier in the misstatements, Mr. Rager and Mr. Dykes owed the company over $9.5 million in 15. That's clearly stated on the audit report, but they went ahead and funded, that's most of the equity, but they went ahead and funded it anyways. And then the appraisal of the real estate. If you go back and look at that loan memorandum, they had a requirement, IBC had a requirement that the loans had to, be 80, the collateral had to, they were only going to loan out 80% of the collateral value. To reach that point, you need to hit $37 million on the real estate value. Well, if you go back to the audit report and you look at the audit report, well, the basis for all the property owned by Rager Dykes, according to my client's audit, it's only $22 million. It's right there. So they're going to have to increase the value of this property by $15 million just to make these loans work. They're ignoring the information that's in the audit report to go ahead and approve these loans. Now, IBC would tell you that just reliance on an unqualified audit is enough in and of itself to establish reasonable reliance, but that's in contradiction to the Grant Thornton case, which is a key case for the court. It's a Texas Supreme Court case. And in that case, the Supreme Court held that it was unreasonable for a lender to rely a hedge fund to rely on an unqualified audit when it had information that the information that this was going to be a risky, this client was a risky business to loan money to.
Counsel, was that a summary judgment case? Was it a tried case or what?
Your Honor, I cannot recall off the top of my head, but it was, all I can recall is that it was decided as a matter of law by the Texas Supreme Court that reliance was unreasonable in that case. I have to go back and look at that to determine if it was a summary judgment case. My recollection is that I honestly don't want to speculate. I just
well, let me ask you this: is reasonable reliance a question of law? Is it a question of mixed law and fact, or is it a question of fact? Or apparently the Supreme Court says it can be a question of law. Is it always?
It is not always a question of law. In fact, most times it's a question of fact. But what the Grant Thornton case says, and the Orca Assets case says, which is a more recent Supreme Court case, is that the courts can decide reasonable reliance as a matter of law. And it's when there's just too many red flags, when someone just sees too much information coming in that makes reliance just unreasonable. And this says courts do have the power to decide that issue as a matter of law. And
is that, I guess, when the pivotal facts are undisputed?
When the facts are undisputed and when they're overwhelming, as they are in this case, you can decide it as a matter of law. The court says, look at all the red flags.
Well, do you want to say overwhelming? Because that seems to be leading towards what Mr. Thetford was saying. You're weighing the evidence if you're saying it's overwhelming.
That was probably not the right choice of words. But if you go back and look at the Grant Thornton case, they say if there's just too many red flags and you look at the consideration of the sophistication of the lender or the person relying on the information, and you compare that, the court does have the power to decide this reasonable reliance issue as a matter of law. And in fact, that's what they did in Grant Thornton and in the Orca Assets case.
Thank you.
We only have a limited amount of time. I'd like to move forward in time and talk about the 16 audit and make sure that everyone understands the difference between the 15 and the 16 audit and the reliance issue there.
And Counsel, before your time does run out, if you can touch upon the settlement versus one satisfaction too. So,
of course, I'll go ahead and jump to that right now so I don't forget it. First off, I want to be clear it's my understanding that IBC has waived this argument because they didn't address it in its principal brief. They just referenced the trial court briefing. And there's a Guerrero case out of Fort Worth, 977 Southwest 2nd, 829, that says you can't do that. That's an end run around the page limit requirements. And of course, your court has said in many cases, including Sunnyside versus Feed Yard, 106 Southwest 3rd, 169, that failure to adequately brief an issue waives that issue. And it's not briefed in their principal brief. But to the extent the court does consider this issue, there's two problems with IBC's argument on this point. First, they miscalculate the maximum damages. And there's a Fifth Circuit case that tells us how to calculate damages in this when a lender is suing for negligent misrepresentation on a loan default. And they say, look at the entire principal amount of the loan minus payments and foreclosure, and you don't include interest. So you get that number, you do the math on that, that's $19.6 million. And the math is articulated in our brief. So that's your baseline number. You don't include the interest, and that I think at IBC's damage calculation, they included the interest on the last page of their reply brief. And then after you set your baseline, then you're going to apply settlement credits. And the settlement credits, that's going to be, there's this issue of, do you apply the Chapter 33 or do you apply the one satisfaction rule? Because they have different applications. Now, IBC is arguing the one satisfaction rule because if under the one satisfaction rule, which is the common law rule, you don't apply unpaid settlements. And there's two huge unpaid settlements in this case. There's a $23 million unpaid settlement with Bart Rager and the non-bankrupt Rager Dykes entities. And there's some debate on how you calculate this. My client's position is that it's a $21 million settlement with the bankruptcy estate. IBC's position is that it's an $8 million settlement with the bankruptcy estate. Either way, they want to argue that the one satisfaction rule. I would argue that Chapter 33 applies because this is a tort case. And under Chapter 33, the literal wording of the statute says you deduct the sum of the dollar amounts of all settlements, which would include these two unpaid settlements. Once you do that math, it completely eliminates IBC's damages on this point.
Real quick on you mentioned the bankruptcy. Is it a bankruptcy settlement versus a bankruptcy claim pending adjudication or something along that line?
It's a settlement with the bankruptcy estate where they've released claims against, they each released claims against each other. They've got an administrative claim for over $1 million, and then they have a Class 11 claim where they get to receive whatever comes through into this creditor's trust, and then it will get distributed out to them. And it's capped at, I believe, $7 or $8 million.
Thank
you. Your Honors, I'm
going to address.
Go ahead.
Oh, I'm sorry. You were going to address the differences between the 2015 and 2016 audit?
Yes, Your Honor. I'll address that. The big difference with 16, in summer of 2017, they approved these loans. Time goes by where they have to go get new appraisals for these loans. So IBC doesn't fund the rest of the collateral real estate loan and $5 million of the Blue Sky loan until February 27th of 2018. At that point, in the interim, my clients issued the 2016 audit report, which IBC claims that it relied upon to fund these loans. But the problem is that the testimony on that point from Mr. Levinson is that it was a clean audit. And that's what IBC is arguing, is that this was a clean audit that they used to rely upon that. But if you look at the standard for a going concern, what a clean audit means is that there's no going concern opinion on the issue, which means that the auditor doesn't have has an opinion that the business may fail after a certain point of time. Well, that time period for the 16 audit only goes up until 12/31/17. So at the time IBC funds the loans on February 27th, 2018, the going concern time period has already expired, and IBC can't rely on that.
Thank you, counsel. Your time has expired. Do any of the judges have any other questions?
No.
Thank you. Thank you, counsel.
Thank you.
Mr. Thetford, you have a 5-minute rebuttal.
Thank you, Your Honor. First of all, the cash flow, guarantee assets, and collateral real estate analysis was all part of the Blue Sky component of the loan. And as Mr. Kaufman points out, that was premised on the release of the $5 million in the Blue Sky loan. It's not till we get to 2016 and the conditions expressly put out there by IBC Bank that they're not going to release the rest of the proceeds till they get the 2016 audit. And that's not debatable. That's by affidavit, that's by testimony of Bill Schonecker, Will Woodring, and Andy Levinson. They all said it was conditioned on the 2016 audit. And the 2016 audit was materially false from the standpoint they ignored over $11 million worth of out of trust vehicles. They, being LGT, ignored over $11 million worth of out of trust vehicles and failed to comment on it, failed to cite it, and all those things. As far as Mr. Kaufman's reference to knowledge about the due on demand and the partnership draw notes, those defects were not self-evident on the auditing report. Keep in mind, IBC has to make decisions in real time. Real time meaning that these notes are getting ready to expire. The debtor is having to do things in an organized and timely fashion. LGT gets to take as much time as they need to conduct their audit, and they did in both 2015 and 2016, with their audit for 2016 being released in November of 2017. So they took almost 11 months to get that right. IBC, on the other hand, is making decisions in real time. And I think that's a very important distinction that needs to be made. I also would reemphasize that, again, we think that Mr. Kaufman and LGT, along with the court, they're weighing evidence to get past this motion for summary judgment. As this court all well knows, that summary judgment standards require that the court construe all facts in a light most favorable to the non-moving party. And there is more than a scintilla of facts to support every one of IBC's contentions in this case. And true, we may be back here after trial arguing some of these same issues, but from the standpoint of the summary judgment crossroad, there is disputes as to whether or not IBC reasonably relied on one set of facts versus another set of facts. There is reasonable question about all of these issues. And I would argue Mr. Kaufman made an outstanding closing argument, but I don't think he got the ball past the minimum standards of the motion for summary judgment. And the other thing I'd like to point out, in that email cited by LGT that was called up on the screen, David Moore was not part of the credit decision. He was doing a post-mortem analysis. That email was done months and months and months after the bankruptcy. So it's mere commentary for the purposes to find out if they can file a claim against their own insurance. And that's the only purpose by which he made those comments.
Well, what do you do with the situation where, or how do you address the situation where some of the defects you're relying on are within an audit that specifically says those defects are in a portion of the audit that weren't audited?
And I would agree with that, Your Honor. I really would. But again, that only goes to the analysis of the first $5 million/$10 million blue sky loan, but it doesn't go to the real estate loans, which were clearly withheld and the proceeds held on to until the 2016 audit occurred, which included cash flow, guarantors, assets, and collateral real estate. And yes, I will concede that IBC did not make a perfect decision on this. And in hindsight, it's always easy to fault somebody who loses and play Monday morning quarterback as to what they should or should not have done. But I believe the court has to look at this in real time, what was happening when these decisions were made, not on any post-analysis, any analysis that was performed, after all the events transpired. And, our bank, this is not the first loan for them to, have a default on, but they do their best at the time. And the real-time component of this case is the analysis that this court, in our opinion, should apply in ruling on this motion for summary judgment.
Thank you, counsel. Your time has expired. Any of the judges have any questions?
Yes, sir.
Thank you. We want to, well, first of all, your case is submitted and you will be excused to leave. But we want to thank you again for working with us to get this argument presented, at least through Zoom. Hopefully in the future, we will have the opportunity, not on this case, but maybe other cases, to see you in person and interact that way. Stay warm and stay safe. And with that, we will be in recess.